Hello and welcome to the AIFC Court and International Arbitration Centre webinar series 2020, New Opportunities During and Post-COVID-19. Today we have webinar 10 in our series. The topic is, Does Intellectual Property Matter in Times of Pandemic? Today's speaker is Justice Sir Robin Jacob from the AIFC Court, who is a leading world authority on intellectual property law. We have 1 hour for today's webinar. Sir Robin will give his presentation, and as usual, we will then open the floor for questions. Please type your questions in the Q&A options shown at the bottom or the top of your screens, and Sir Robin will answer the questions at the end of his presentation. By way of a very short, quick update from me, if I may, on our Court and Arbitration Centre, I'm very happy to confirm that we continue as a Court and Arbitration Centre to operate 100% online during the pandemic, using our latest digital technology for e-filing, called e-justice, and video hearings and telephone hearings. We are 100% online for all dispute resolution. We have so far, across the Court and Arbitration Centre, administered a total of 87 cases. These cases have been enforced to 100% satisfaction. We have now attracted 155 lawyers from all around the world, from 21 jurisdictions around the world, for rights of audience at the AIFC Court. Our services continue to be provided free of charge, and we really believe now that we do have the infrastructure and people in place to provide truly world-class dispute resolution for quick and cost-effective dispute resolution, applying the very highest international standards of the rule of law. Thank you very much, Sir Robin. I now hand over to you.
Thank you, Chris. The title is really what I'm going to address. So I'm not going to be technical. I'm not going to be discussing interesting questions of patent law or copyright law or design law. I'm going to talk about policy, and I'm going to tell you to some of the things that actually happening, because I'm fortunate that I keep in contact with quite a lot of things that are going on. Do IP rights stand in the way of dealing with the crisis? Or are they a driver to help find a way out of it? Or are they really rather irrelevant? I begin with a Latin quotation. Silent enim leges inter arma. In 52 BCE 52, Cicero, the Roman statesman and orator, used those words in his defense speech on behalf of a man called Titus Milo on trial for murder, who said he'd done it, or his defense was he'd done it in time of war. And the Latin phrase is loosely translated as, in times of war, the law falls silent. A great English judge, perhaps the greatest English judge of the last century, did not agree. In the middle of the Second World War, he, in a very famous judgment, he said this: in this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. To some extent, these conflicting views of the law in the context of IP laws in the time of COVID-19 is being debated. To some extent, as I shall demonstrate, particularly in relation to patents, probably the debate is utterly irrelevant. In copyright, it's more difficult. I am, of course, talking about intellectual property rights, and they go by the general name intellectual property, but really those rights have little in common except this, that they are rights to exclude others. There is a very big difference between a patent for an invention and a trademark. Commercial purposes are different, everything is different, but they both give the right to stop other people from using them. Designs can be things like new handbags, which have no relevance to the world of COVID, but they can also include industrial designs for things like ventilators and medical devices. Copyright covers many, many different sorts of things, artistic works and so on, none of which matter at all in the time of pandemic, from the point of view of dealing with the pandemic. One area which do matter, however, is literary works, books. What is to happen when the libraries are closed, when students in universities cannot go to the libraries? And universities have become virtual universities, as indeed my university has. I may have time to touch upon related subject, privacy and tracing, but we'll see how we go. Let's start with patents for inventions, new medicines and new devices. Before we come to COVID-19, I don't have to turn that sound off, I'm sorry. Before I come to COVID-19, I want to talk more generally about the patent system and its relation to pharma. Some say it should be abolished altogether, that it's a bad thing, that it gives people private monopolies, and the world would be better if you didn't do that and maybe had a substitute system like prizes, but anyway, patents are evil. Others, not so extreme, say the patent system should be diluted, particularly by systems of compulsory licenses in the field of medicines. This kind of abolitionist and or dilution, but particularly abolition thinking, has been around a long time. There's nothing new about it now. Here is what the great thinker Jeremy Bentham wrote in 1792. It gives me great pleasure to mention him because we have his mortal remains in a box in our college. He called it an auto icon, and Chris will know it well, and he had something to do with the foundation of my university, although a little late. He did buy £100 worth, a lot of money, shares in the new university. This is what he wrote in 1792. So this is just at the beginning of the Industrial Revolution. The age of steam is just coming. So long as men are governed by unexamined prejudices and led away by sounds, it is natural for them to regard patents as unfavorable to the increase of wealth. So soon as they obtain clear ideas to annex to those sounds, it is impossible for them to do otherwise than recognize them to be favorable to that increase, and that in so essential a degree that the security given to property cannot be said to be complete without it. Patents are property. Abolitionists and diluters, I should just mention, by the middle of the 19th century, there was a very strong abolitionist movement, so much so that in some countries, the system was abolished altogether, Holland particularly, and it was very dilute in Germany, which is, particularly Germany didn't give very good protection or any protection to chemicals that had been made abroad. They only gave protection to processes, which is why a whole lot of companies set up on the border with Germany to make chemicals. And the great Swiss drug companies are all in Basel. Abolitionists and diluters say patents lead to high-priced medicines which the poor and sick cannot afford. And it is true. New patented medicines are expensive, though their period of monopoly in practice is seldom more than 10 years and quite often less. The reason is, although a patent lasts 20 years, it takes at least 10 years to get permission to sell the drug, because it takes that long to find out properly that it is safe and works. Think of this, however. About 20% of the price, not the profits, of a patented medicine, maybe a bit more, in the Western world, in the developed world, goes back into research in finding and developing new medicines. And think of this. The big pharma companies, overall between them, spend about 4 times more on research and development into new medicines than the combined spending of world governments and charities, such as Gates and Wellcome. And world governments includes money they give to universities, so you can't double count, and so on. And the figures are huge. My own rough calculation a few years ago was that the spend of pharma companies was around $120 billion. governments doing 30. And here is another hard truth for abolitionists and diluters. No new medicine has been brought to the market since penicillin in the war, save by a pharma company. Even those few medicines which have first conceived in a university have needed the resources of big pharma companies to develop them. And as far as I know, no government has ever invented a new medicine, still less developed one. Let us consider COVID. We're not sure there is any medicine which is going to be good for COVID. I'm not sure I would take President Trump's recommendation of Clorox or hydroquinone. There may be some medicines, existing medicines, which have got permission and are but really haven't been very successful for one use, but they may be, and it may be they can be repurposed for COVID, either curing or at least alleviating the disease. There is a possibility of one or two that may reduce the time of extreme cases, which might mean more recover from it. Does anybody seriously think that the patent system is getting in the way of people trying to find out whether any of these medicines, these existing substances, work or may work? If they do, I suggest the challenge is on them to say, well, come on then, which medicine is not being investigated and why is the patent system getting in the way? There is no evidence whatever that is so. On the contrary, there's much talk around the world of repurposing existing medicines, and people are trying. The patent system doesn't even prevent research into new uses of old medicines and never did. As for a new medicine for COVID, well, the time scale is very, very short. It's very difficult to find one. How do you do it? I mean, obviously people would be trying if they could, and they are, but establishing it really works and is safe is a monumental task. No doubt it can be hurried up, and maybe there's no alternative. But the patent system is not in the lightest bit getting in the way. It may even be encouraging it a bit, because some people say, well, if I can find something, I'll make enough for the world. And what's the problem with that? I make a bit of profit. You know, sometimes the people talking about making profits out of medicines as though it's something wicked is ridiculous. You say doctors shouldn't be paid. Hospitals shouldn't pay rent. You could just take any property over and say, well, I'll turn it into a hospital. Mask makers shouldn't get any money. Oh, it doesn't work. So why are medicines so different? Now, I understand that if medicines are in short supply and become overpriced, something can be done about it. But there's no evidence of that at all. Of course, a lot of work is going on now without the profit incentive. There's that old saying, necessity is the mother of invention. But if a candidate works, emerges, which may work, you can bet your bottom dollar that people will be researching it as hard as they can. However, that research, laboratory-wise, can be done in universities, but as soon as it comes to significant trials in patients, it is only Big Pharma that can do it. Only Big Pharma can find out if it is safe and actually works. And it has much experience of things that they thought were going to work and come to the big trials costing billions of dollars, costing possibly $500 million, and they failed at that stage. And that may happen here. What then about vaccines? You need to know something about the manufacture of vaccines. There are a lot of people who make noises, oh, pharma will be charging a lot of money for vaccines and so on and so forth, and they'll be holding the world to ransom. There's not the slightest evidence that's ever happened with a vaccine yet. Actually, the vaccine business is not terribly profitable. There are only about 6 companies in the world which can make vaccines on the scale needed. And we should be very grateful for them. If they didn't exist, we'd have no prospect of a mass vaccine. And curiously, patents have very little to do with vaccines. Vaccines are typically not patented, complicated for technical reasons. The problem is actually that making them requires huge skills and significant manufacturing resources. Not even all the big pharma companies think that vaccines are worthwhile. Maybe the world should be thinking about encouraging vaccine manufacture more, not just for COVID, but maybe post-COVID more generally. And perhaps also because we may yet need another vaccine against another pandemic. Most people seem to think that pandemics are going to be more and more likely. Indeed, although COVID wasn't itself foreseen, what was foreseen was flu. The Spanish flu of 1918-19 killed nobody knows how many people. Of the order of 50 million is the best, but the highest estimates are 80 million. It killed my grandfather. So vaccines are difficult to make and expensive to make. Now, there are a number of initiatives and possible candidate vaccines, and they're all being pursued. Maybe about nearly a dozen. Nobody knows yet whether they've got one that works. Not so easy to find out if it works. First thing to do is to find out if it's safe. Oxford University came up with a possible candidate, and it has been tested for safety. And Oxford have partnered up with Big Pharma, AstraZeneca in this case, a UK multinational, which only last week announced that it, in cooperation with others, India and others, are investing in a project to build a capacity to make 2 billion vaccine doses by the end of this year. It's a big investment in the technology to do it, and they don't even know yet whether they're going to want to make it. And they have said it's going to be made on a not-for-profit basis. I have said already the vaccines are not very big. They don't have a huge markup on them. If you're going to make a vaccine, you can make some money out of it simply because you make so many. But there's nothing of the same order of difference between manufacturing cost and ultimate price as there is with new medicines. These big pharma companies could not exist. They couldn't be there to help us, but for the patent system, which has enabled them to build the mighty resources they've got. There's not the slightest evidence that patents or intellectual property rights have got in the way of research for a vaccine. There is quite a lot of hot air being generated by anti-intellectual property people. I'm afraid, some of the non-governmental organizations have got the idea that somehow patents are standing in the way. And it's a great pity because there are more important things to worry about. The debate should stop, which is worse than pointless. It is a time-wasting distraction. I must describe some other developments. There have been several initiatives around the world to encourage IP owners to license their intellectual property rights for free in connection with COVID-19. In the United States, for example, there is the initiative of two friends of mine, Professors George Contreras of Utah University and Mark Lemley of Stanford University. They call it the Open COVID Pledge, and it's worth Googling it and having a look at it, whereby a company may grant a free license under its intellectual property rights, patents, sometimes copyright, sometimes both. Other organizations have done the same. Imperial College London has done much the same thing with contracts drafted by a professor in my faculty. This is what the Open COVID license says. Having made the Open COVID Pledge, we, the pledgeor, that will be the company, in order to speed the development and dissemination of the technologies needed to end the COVID-19 pandemic and mitigate the effects of the disease, grant the license described below. Our intent in doing so is to advance the shared cause of ending the pandemic, and we do so without any expectation of consideration or compensation and with knowledge of the rights we are licensing. And then the license goes like this. The pledgeor grants to every person, entity that to wish to accept a non-exclusive, royalty-free, worldwide, fully paid up license for the sole purpose of ending the COVID-19 pandemic. And it ends, the license ends 1 year after the World Health Organization declares the pandemic to have ended. There are other clauses, but it doesn't matter. How important this pledge is, I'm not sure. Quite a lot of companies have signed, quite well-known companies, but largely their intellectual property is simply not relevant. Microsoft, Intel, Amazon, IBM have all signed, for example. Pharma has not. Big pharmas have not. I'm not surprised or disappointed. I agree with them. They are doing their bit already. They are working on it, and there isn't a problem. Well, it really is important to understand there is simply no patent problem with development of all aspects of pharma, from testing, treating, and vaccines. All of them. The world is going as fast as it possibly can. Nor is there a problem in the field of medical devices, of which I suppose the most prominent example are breathing devices, ventilators, and another one I'm going to tell you about in a moment. It is particularly spectacular, and I'm very proud that it came from my university, University College London. Some doctors and engineers met in a pub in early March, just before lockdown on a Friday. And they came up with a plan to design an improved breathing device called a continuous positive airways pressure device. It doesn't actually get put into your throat. A full ventilator does that, but it's a mask which helps you breathe. It was based on an old one, but it was much better. Within days, they had the new design and were in collaboration with a number of parties, particularly Mercedes F1 engineers. UCL's engineers are friends with the Mercedes team. They managed to change government policy, which had been concentrating on full ventilators, got the legal sorted, got the approval sorted, and everything was fixed. And within a month, a program for building 10,000 devices for the National Health Service, or at least National Health Service England, had started. Other countries asked whether they could be supplied too, but the decision was made not to do that. It was not going to be practical, but instead, University College and the designers made the plans and designs available for manufacture freely anywhere in the world, and they are being made in quite a lot of countries now. They are manufacturing drawings. And it's turned out to be in some ways more important than people thought, because the CPAP device is turning out to be probably more important than full ventilators. It's a heartwarming story which shows that in times of crisis, you don't need to incentivize innovation. I'm going to go a bit legal here now. Supposing somebody who had an intellectual property right, say on a medicine, sued somebody who was infringing their patent and could not themselves fully supply the market at a reasonable price. Would any court in the world grant an injunction to prevent manufacture or sale? The answer is no. There are some legal difficulties in some countries where they take a rather rigorous view, sort of wooden view of the grant of injunctions. If the patent is good and the defendant is infringing, it's automatically an injunction. We don't do that in the common law world, and it wouldn't happen in the AIFC court. If there was a contract or something, no judge with the power to grant an injunction is likely to grant an injunction in respect of anything to do with COVID if the patentee cannot himself supply. Of course, if he can, then no reason why he shouldn't supply. Good luck to him. What would we pay now if somebody came to now? It's a bit like the Pied Piper of Hamelin, which some of you will know. The old story, the German story of the the town of Hamelin beset by rats, and nobody could do anything about it until this strange man wearing strange garb, pied garb, that's why he's called Pied Piper, with a pipe, said, I can solve it for you. Will you pay me 1,000 guilders? And they said, yes. And then he did, and they wouldn't give it to him. We're a bit like that now. What would we pay for something that could magic this away? So I've had enough of talking about pharma and direct treatments. I just conclude with saying, thank goodness we hope those pharma companies, that if we can find a vaccine or a medicine, are there to make it on vast scale very quickly. Here, I now go to copyright and a very different intellectual property right. And here I think COVID has had a huge effect and will have a huge effect. Again, it's not a question necessarily of suspending copyright rights, but I think things are going to change a lot, and they may have to change some more. And the big example is libraries. We've already had the example of companies like Netflix and other streamers are doing very well out of COVID. Nobody's really having a big attack on them for doing that. They're saying it's happening and somebody ought to do something about it, but not much. You haven't got the same song and dance that are being created about patent rights, even though there's no problem with patent rights. What about things that are not going so well? And as I say, libraries. The university libraries of the world still provide, depending on the subject, students and researchers with physical books, and they are closed. Can the libraries provide things virtually? We lawyers are probably not touched by it very much, because our world has become to some extent virtual already, with things like Westlaw and their subscription system, and students get Westlaw free. It's a bit like a drug dealer, the old drug peddler. They get the students hooked, and then they go to their law firms, and they've got to pay, the law firms have got to pay for streaming. So I'm not complaining, it's a very sensible business, and indeed we are going to be online. But other subjects are not the same. They haven't got a vast publishing industry creating an online streaming service. The UCL's librarian puts it this way: every year they buy about 20,000 books for all different subjects which are put into our great library. For the same money, just have a little guess yourself, how many online books could they buy at current prices? The answer is astonishing. 80. That's no use to man nor beast. As I've said, some students are not so much in trouble because of the publishers are already putting stuff online, and the students are given it free. But libraries, where do they go? Well, one way, and that's being promoted in my university, is to create a home university press with open access. We have something called UCL Publishing, which has been very successful in some regards. But it's huge. One of their books has been immensely successful all over the world. It's on surgery, and people have taken it up, and there are thousands of downloads from around the world. Number two, libraries close down and physical books become non-existent. Physical textbooks, they're all virtual. Publishers, there's a third possibility, will set up a system analogous to Spotify, which is for music. You no longer make your money by selling books, you make your money by usage. Just as Spotify, you make money by streaming and not by sale of CDs. All this is seriously affected, I think, by COVID. In the end, I believe we will move to a usage-based pay system. I hope it's a bit less chaotic than Spotify, where Spotify takes the money and there are huge fights between different rights owners as to who should have enough. And of course, Spotify wants to take most of it anyway. But I think COVID will push rights owners in the virtual direction significantly. If, of course, open access system becomes the norm, and of course, it's quite easy to have open access. We've done it at UCL, other universities will probably do it. The academics who write these books are not really expecting to make any money out of them. I've written textbooks and so on and made a brass farthing, really. You couldn't buy a decent case of wine for what I get in royalties a year. And so publishers may themselves find that if they don't adapt, they may fade away. I say nothing about trademarks. I don't know that anybody suggested they've got anything to do with the COVID crisis, one way or the other. I've mentioned designs in the context of devices. Some laws protect devices of that sort beyond the patent system, and they will be potentially applicable to new COVID devices of various sorts, but it doesn't matter. And artistic designs no longer don't matter at all in this context. One thing that does matter, perhaps, are trade secrets, which is sometimes called intellectual property, sometimes not. Because trade secrets do matter and are not easy to control. Because if you give a trade secret away, you can't get it back again. Currently, the vaccine makers are prepared to do that, although the trade secrets appear to be, on the evidence is, they're not just trade secrets, they're trade skills, which you can't just write down, and skilled teams. I mean, everybody can play football, but only Liverpool can play like Liverpool. And a team is maybe not copyable. That may be the kind of protection that these vaccine makers will get when they produce us a vaccine. But in which case, it's nothing to do with the law. It's just the way it is. I want finally to touch upon test and tracking devices. Here again, there's been a huge amount of work being done. Not, I think, entirely rationally necessarily. Huge collaboration between Google and Microsoft to produce a device which involves the operating systems so that they will function on Bluetooth. They are doing it. Involves Apple almost departing from one of its fundamental tenets. We never give anybody access to anything. And then there are privacy problems. I've mentioned in the course of this cooperation, the idea of companies cooperating in something which they're then going to sell or make available for money is an anathema to competition lawyers. Also, in some parts of the world, the concept of governments giving money, state aid, is unlawful. So what do we do about those aspects of the law? Well, what's actually happening is really Cicero. They have just simply let the law fall silent. So the European competition authorities are saying, well, we're not going to investigate and complain if companies get together, as they are doing. I don't find that intellectually satisfactory. The better way is to say, well, You know, it's not good enough really for the policeman to say, well, I'll look away and you can commit this crime because it's actually quite a good thing for you to do it. It's better if you were to say, actually, competition law should have an exception for times of crisis. State aid law should have an exception for times of crisis and be lawful. Going back to patents, incidentally, that is exactly what many countries' laws have. My country, United Kingdom, has a system for government use of patented inventions. And what's more, that in times of crisis, in case of an emergency, that right can go further and become compulsory license. None of it's been necessary, but there are powers, lawful powers, so that you alter the position in times of war. But you speak the same language in peace as in war. And that is really important, because if you start disregarding laws in times of crisis, you may be sowing the seeds of something even more dangerous than the disease itself, unlawfulness itself, tolerated by states.